Hello and welcome everyone. I hope you have had a great learning experience so far. By now you must have gone through various concepts of information and communication technology and learned a lot of things about various kinds of cyber crimes, various theories, internet governance and so many other concepts. This week also you must have learnt about computer forensics and the various stages which are important in the forensic process. Today we are going to learn about a new topic which is equally important, digital evidence and its broad principles. The learning objectives of this module are going to be to know the legal provisions and their amendments therein with regard to digital or electronic evidence, to understand the concept of digital or electronic evidence, to understand the principles of admissibility of digital evidence, to know the proof of admissibility, to find standard of proof of digital and electronic evidence, to identify the appreciation of digital or electronic evidence by the court through various case laws. The module overview is as follows. In this module, we are going to discuss the concept of digital evidence. We'll have a detailed discussion about the topic of digital evidence and various broad principles with special reference to the Indian cyber law. This module introduces the concept as well as all the legal provisions which are relevant along with the amendments with regard to the digital or electronic evidence. We would also discuss the development of the concept of digital evidence, the principles of admissibility of digital evidence, legal provisions relating to the proof of admissibility of digital evidence in India. This module would also highlight the standard of proof of digital or electronic evidence and appreciate the evidence as laid down by the Indian judiciary. So first let us understand what is meant by digital evidence or electronic evidence. Well, according to the Black's Law Dictionary, digital evidence is something that tends to prove or disprove the existence of an alleged fact. In simple words, digital or electronic evidence may be defined as a piece of evidence generated by some mechanical or electronic process. It inculcates but is not restricted to emails, text documents, spreadsheets, images, graphics, database files, deleted files, data backups, located on floppy disk, zip disk, hard drives, tape drives, CD-ROMs, PDAs, cellular phones, microfilms, pen recorders, fax, etc. Well, the main drawback of the Indian Evidence Act 1872 was that it did not appreciate the admissibility of digital evidence or electronic evidence at all. It did not have any of the legal provisions in it which could recognize digital evidence and make it admissible before the court of law. Substantially, it was not at par with the modern technological development. Therefore, to recognize the transactions that are carried out through electronic data interchange and other means of electronic communication, law was required to be amended. With the advent of Information and Technology Act, it was very important to amend other acts also so that the principles of digital evidence or electronic evidence can be appreciated and they may be considered admissible before the court of law. Therefore, in the year 2000 when IT Act came, the Indian Evidence Act 1872 was also amended. The other acts which were amended were the Indian Penal Code 1860, the Bankers Book Evidence Act 1891. In order to make the electronic evidence admissible, the definition of evidence has been amended to include electronic records. The term electronic records provides for data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche. Electronic form has been defined under section 2 clause 1 subclause R. It means any information generated, sent, received or stored in media, magnetic, optical, computer memory, microfilm, computer generated microfiche or similar device, whereas the term information includes data, text, images, sound, voice, codes, computer programs, software and databases or microfilm as well as computer generated microfiche. With respect to the admissibility of electronic evidence, there are various legal provisions which have been inserted by the amendment. The amendments brought into the Indian Evidence Act 1872, they were really important, and now they have changed the entire scenario which applies to digital evidence or electronic evidence. The important sections are: Section 5 of the Evidence Act provides that evidence can be given regarding only facts in issue or of relevance. The relevant sections here are Section 65A and 65B. 65A provides that the content of electronic record may be proved in accordance with the provisions of Section 65B. What is Section 65B? We are just going to discuss in a couple of minutes, but another relevant section before that is Section 136 of the Evidence Act. This section empowers a judge to decide on the admissibility of the evidence. Before we move on to discuss Section 65A and B, which were inserted in the Indian Evidence Act by an amendment, it is also important to discuss what are the various kinds of evidence. So there are mainly two kinds of evidences: primary evidence as well as secondary evidence, and they have been appreciated under the Indian Evidence Act. Primary evidence, this is considered to be admissible under Section 62 of the Act. Section 62 lays down primary evidence means the document itself produced for the inspection of the court. There are two explanations attached with the section. Explanation 1 says that where a document is executed in several parts, each part is primary evidence of the document. Where a document is executed in counterpart, each counterpart being executed by one or some of the parties only, each counterpart is primary evidence as against the parties executing it. Explanation 2 lays down that where a number of documents are all made by one uniform process, as in the case of printing, lithography or photography, each is primary evidence of the contents of the rest. But where they are all copies of a common original, they are not primary evidence of the contents of the original. The section also lays down an illustration. It says a person is shown to have been in possession of a number of placards, all printed at one time from one original. Any one of the placards is primary evidence of the content of any other, but no one of them is primary evidence of the content of the original. Section 63 lays down what is meant by secondary evidence, and it gives lot of illustrations also to make the section very clear and understandable to us. Section 63 lays down secondary evidence means and includes certified copies given under the provision hereinafter contained, copies made from the original by mechanical processes which in themselves ensure the accuracy of the copy, and copies compared with such copies, copies made from or compared with the original, counterparts of documents as against the parties who did not execute them. It also includes oral accounts of the contents of a document given by some person who has himself seen it. The illustrations of this section are given in the section itself. One of the illustration is a photograph of an original is secondary evidence of its content, though the two have not been compared, if it is proved that the thing photographed was the original. Similarly, a copy compared with a copy of a letter made by a copying machine is secondary evidence of the contents of the letter if it is shown that the copy made by the copying machine was made from the original. Another illustration says a copy transcribed from a copy but afterwards compared with the original is secondary evidence, but the copy not so compared is not secondary evidence of the original, although the copy from which it was transcribed was compared with the original. Section 64 is quite simple and easy to understand, yet very important, yet very relevant. It lays down the proof of documents by primary evidence. It simply says that if the documents or evidence has to be proved before a court of law, they must be proved by primary evidence only. But after section 64, the two most important and relevant sections which has actually changed the course of the way digital evidence have been appreciated, the two most important sections are section 65A and 65B. Let's look at both these sections. Section 65A lays down cases in which secondary evidence relating to documents may be given. So 65A lays down the special provisions as to evidence relating to electronic record. It simply says that the contents of electronic records may be proved in accordance with the provisions of section 65B. So actually, the entire procedure for proving the digital evidence or electronic evidence is laid down under section 65B. It's a very comprehensive section, yet a very important one. Let's look at how is it worded. 65B lays down, notwithstanding anything contained in this Act, any information contained in an electronic record which is printed on a paper, stored, recorded or copied in optical or magnetic media produced by a computer shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without further proof or production of the original, as evidence of any content of the original or of any fact stated therein of which direct evidence would be admissible.